Okay, and this part's a little bit slower than it usually is because our statewide computer system that services all the courts in the state is offline and has been for a week. So it slows us down a little bit. So I'm just going to ask for your patience. Now, according to my records here in the court file, I do not see that there's been service of notice or the petition on Santos. You have that with you? Yes, okay, can you bring it on up? All right, unfortunately, the court will not be able to accept this as service of process for a couple of reasons. One is it doesn't look like it meets the requirements for electronic service, but second and most importantly, it doesn't indicate what, if any, documents were served on the respondent. At a minimum, the requirements for this would be to serve notice of the notice of the hearing itself, also the petition. Mm-hmm. And there's not an indication here that was served. I'm going to give this to you to put into the court file. Okay, so your options at this point, let's see, just give me a second here. Like I said, we're kind of limited in what we can do. So this petition was filed in September. All right, we got original notice of hearing. So your options at this point would be to ask the court to set a new court date for you to get the respondent served properly, or you can dismiss your petition.
Okay, I still want her I want a new court.
Okay, that'll be the last time. If she's not served the next time, the petition will be dismissed. And Kayla, we don't have a temp in this one, so scheduling is wide open. Yeah, you prefer the 25th of November or December 2nd?
I can do the 25th of November.
Okay.
I do have a question, Your Honor.
Yes.
Is this like I serve her all over again, or
yes.
is it?
Okay. You have to serve her, yes. Yeah, I can't really give you advice on how to do that, but it's, you know, it sounds like you're already working with somebody who does that, so I could probably give you some advice on that.
Okay, thank you. That's at 9 a.m.
Yeah, it'll be the clerk has it. It'll be 9 a.m. again, just like this. And November 25th will be down at the regular courtrouse in courtroom 3.
All right. Now I'm going to call the one-party cases. Michaela Greenwood Hill.
Yes, Your Honor.
Okay, and I am going to make a final call for Tamaya Santos.
I'm sorry, what'd you say, Your Honor?
I'm making a final call for Tamaya Santos. All right, I'm still not hearing an answer.
Okay. She refuses, Your Honor.
Well, I have to check my court records here. It appears that there's still no service on Tamaya Santos. So as I indicated a couple of weeks ago, there would be no further continuances of this. It looks like the methods of service or attempted service are exhausted, and the petition will be dismissed. There was no order issued initially in this case. All right, this Greenwood Hill, the petition is dismissed, and that will conclude your case for today.
Yes, Your Honor.
All right, and next, Ms. Carlisle. Got you just fine.
Is mine working, Your Honor?
No, Mr. Abbey, your connection's not stable. You're breaking up.
Sorry, Your Honor, I have bad connection issues at where I live by Summit Lake. Is it working okay?
Yeah,
seems to be on this end.
Yeah, let's see how well it does. For now, it seems to be okay. All right, so we're gonna go ahead and proceed with your hearing. So let me explain to you just quickly how this works. So what I'm going to do is swear both of you in, and then Ms. Menzies, you're the petitioner here. You'll get to go first and present your case. That means you can testify yourself. You can refer to exhibits that you've previously filed, and you can call any witnesses that you may have brought with you. After I hear from you, then Mr. Abbey, it'll be your turn to do the same thing. Testify yourself. Point out any exhibits that you think are important, or if you have any witnesses, they can testify. After I've heard from both of you, I'll make a decision on whether or not the protection order that was previously issued ex parte will continue in any form. And I'll explain to you why that is, why the basis for my decision. Okay, so we're going to get started here. Both of you, please raise your right hands. And do you both swear the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right. Now, Ms. Menzies, you get to go first, and call this as case 24-377. And keep in mind that everything that you filed already, the petition that you filed is already part of the record. So it's not necessary for you to repeat everything that's been said in writing before or filed before. But go ahead and Ms. Menzies, and tell me your side of it.
Thank you, Your Honor. I don't have any additional evidence or anything other than what you already have to provide to the court today, nor do I have any witnesses. I just have a prepared statement. It's been extremely difficult for me, so I just want to read this. And
okay.
I'm requesting this order against Baron Abbey due to the very significant emotional, psychological, and physical harm I've suffered. I'd like to share with the court the ongoing impact that abuse has had in my life, and why I fear for my safety if this order is not granted. Since experiencing these incidents, the last one being on 9/15, which you have evidence of, that is the last one, but it certainly was not the first one. The physical attacks, the verbal assaults, and the constant fear that I experience have caused me tremendous psychological and physical effects. Anxiety, depression, sleeplessness. I carry a permanent scar on my face from Mr. Abbey. His injuries inflicted on me. I'm fearful that without protection from the court, he will continue to intimidate me, harass me, and spread vicious rumors about me on social media and through my friends and family, preventing me from feeling secure and safe in my daily life. This abuse has affected me in every aspect of my life. I've had a difficult time going to work, working for a full day, interacting with my friends and family, and even carrying out just everyday tasks. Going to visit friends who live in the vicinity of Mr. Abbey, and being fearful that he will see me or find me. I have been afraid to be home alone. I'm just requesting this restraining order, not just for my protection, but also for the hope of reclaiming a sense of normalcy in my life and some security. I fear that without this order, I am going to be at continued risk of harm from Baron Abbey, and I ask the court to help ensuring my safety and granting this order so I can begin to move forward. And thank you.
Thank you, Ms. Menzies. All right, Mr. Abbey, it's your turn to tell me your side of it.
Okay. Thank you, Your Honor. Darcel and I had a loving relationship for several years now, 4 years, and for the last, 2 years or so, she'd been living with me at my home. I began to suspect there was problems though going on, and I had no way to know what they were. So I actually had used some recording device, a high-end recording device, to figure out what went on when I left the home. And I found out some astonishing things. And I confronted Miss Menzies about it, and she would not answer any questions about it. This continued for, something like 9 months. But things were rosy in the garden for the most part. The summer came. We'd go to the lake and enjoy ourselves and did some crafts and things and that we enjoyed. But I started listening to some of these recordings, and things were going on that were inexplicable to me. Number one, she was whispering continuously to people that it made no sense to me, and she would not acknowledge that when I confronted her about that. And it wasn't until after I'd asked her to leave on or about the 15th. I think it was more like the 16th, but that I began to be able to put these recordings on the hi-fi stereo and listen to them and actually get some sense of what was being said in the recordings. I don't wish to go into great detail about what I learned about it, because I want for the welfare for Miss Menzies to be able to continue working and to not have her life upset in that way. And as for that incident she says it was on the 15th. I think it was on the 16th actually. What had happened was we got into a great big argument involving these recordings. Now, on these recordings, I was hearing men come and go into my house, and this would detail by the door opening and the footsteps coming in or going up and down the stairs after I left. And I confronted her about this, and she just said that it was fake, that it was all my imagination. And so we got into a big heated argument about that. And it was near the end of that argument at that time. Mrs. Menzies was very heated up when we were talking about that, and maintained it was that none of it was true, which, I had referenced and gone back to some of these recordings, and these things started a year ago, and it upset me greatly that I wanted to find some kind of resolve to this. But I consider myself a very forgiving person. I mean, there's one incident happened in March, sir, Your Honor, that I was convinced that she was cheating on me and or seeing somebody else or something. It turns out I was right. But at the time, I backpedaled and said, I made a statement on Facebook to my shame that because I think personal business should be kept personal, but I'm kind of a loner out here where I live, far from the city. Anyway, to not stray too far from the story, I backpedaled and said, no, it was all my fault. Sorry, everybody. I love Darcy. She's a good person. And anyway, moving back forward, I found out that this had been going on for a year, and she would not address it. She wouldn't explain to me what was going on. The more I learned about these recordings, and the better I was able to use my knowledge of sound systems and music, which is the only reason, by the way, I was able to create a zip file. And I had to handwrite the other things because I don't have computer knowledge the way Miss Menzies does, and most other people actually. But it reached a crescendo at that point because I knew that there was men coming and going, and that it was all just whispers. I could only pick up little bits of what was being said and done, and it really upset me greatly. And she continued to deny that, and we got into an argument. At some point, the argument had reached the level of where we weren't communicating very well together. And Miss Menzies just started screaming at the top of her lungs. Almost, I don't really want to describe it but it was like a child that wasn't getting what she wanted. And she was screaming at the top of her lungs continuously. The time between breaths was barely noticeable. And even though my neighbors are about 400 feet away, and we have pretty spacious areas to live out here, but not on the lake, mind you, but up the hill, I had great concern for my welfare, as she sounded as though she was being murdered. And at this point, I didn't know what to do. And so what I thought of was, I saw this cup of water. I reached down, grabbed the cup of water. She didn't seem to be. I was telling her, please stop. People would think that I'm abusing you or murdering you or something, and I haven't laid a hand on you. And she kept screaming. It's really difficult for me to try to explain how loud it was, because it was extremely loud as one could possibly scream. And it just kept going on and on, kind of like, only at such high volume. I didn't know what to do. And in fear for my own safety and welfare, I grabbed a cup of water and thought that I could splash some water on her. Maybe she'd snap out of it and come back to earth and quit being hysterical. And what happened was, I grabbed the mug of water. It was an insulated mug. I went to splash some on her, and the mug slipped from my hand, and it bounced right against her nose. and it started bleeding. And I said, "Oh my God, I'm sorry, honey. I'm sorry. It was an accident." And so I went and ran and grabbed a washcloth, and she it was, it was a horrible accident. I had no intention of her being hurt by that. I just wished that she would stop screaming. Well, anyway, we kind of got past that, although I couldn't get past the fact that she'd been inviting men into the house, and it seemed very likely that they were doing something other than just talking. And anyway, so by the next morning, I wanted her to leave that night, actually. But after that happened, I sort of backed off, and she explained to me she would ruin my life if I kicked her out that night. Or if I made her leave that night, not kicked her out. I don't know if that'd be the right term, if I made her leave. And so I backed off. But the next morning, I insisted that she leave because I knew that there had been men in the house, and she promised me that there'd never been any men in the house. She never cheated on me, and all these things that I thought were in my imagination or something. I knew this wasn't to be true, and well, since then, I listened to the tape some more, and at one point, it seemed as though two of the guys that she was seeing, excuse me for a moment, it seemed as though they were poised to go out and shoot me. To my astonishment, when I heard this recording, I was still trying to figure out who were these people she was seeing. And she had called him back and said something like, "It's not the right time yet." And at that point, I was practically horrified. Now, this had occurred 6 weeks earlier, but I called the police then and got a restraining order against Miss Menzies. And I didn't go to the temporary hearing, though, Judge. I had some hope that her and I could work this out between us, and believed that we could do that, in fact, and that wouldn't have to involve everyone else. And I still, I still think that we can work things out. I just know that we can't be together because of the things I experienced. And I'm sorry for her difficulties, but I got a restraining order against her. I felt my life was in danger at that point. I didn't know what her intentions were. I didn't know what the intentions were of these men that have been into my house. She said it had never been there. And but at some point, before the temporary hearing, at that point, we still contacting each other. She was not being responsive to working anything out to resolve the problem that we have between us. And now on she and that I have training order, which I think is for a lot of them. One of the people that was holding on point seemed poised to go and attack me, although she ordered him down. It seemed to me too. These things sound incredible, but that's what I heard. And I asked Miss Menzies about it, and she would not explain or give me any answer about anything or admit anything about anything. So we're left at that.
Sister Abby,
Yes.
I want you to kind of stop right here. You're getting to the point where you're repeating yourself. And so I want you to just take a minute or two and close this up, and then I'll make a decision.
Okay. All right. Very well. Well, Miss Menzies, I believe, responded by getting a restraining order against me, since I'd had one against her, and then came up with this list of grievances, things that I had done. Now, she was doing things that she wasn't supposed to be doing while working, in my opinion. And having people in my house, she said that she wouldn't never have. There was never any men in my house except for a couple of times. We lived way out in the sticks. Well, I went back and listened to all the recordings. There was men in the house every single time. And I had a hard time reconciling that. So I just know that we can't be together. I think she ordered the hearing or the protection order as a response to my doing it. And if I hadn't done it, we would have ironed this out somehow, although it would have been bumpy. But that's about where it sits. And I'll hand it back to you, Judge.
All right.
Your Honor,
I've heard I've heard from both sides. I've reviewed the material that's been submitted by both parties. It's clear to me, far beyond the preponderance of the evidence standard that I'm applying, that Ms. Menzies was a victim of domestic violence. That's substantiated not only by the things that she said in her petition and repeated many of them today under oath, but also the photograph that she submitted in support of her assertion that she'd been assaulted. And that photograph certainly supports that. I've reviewed the evidence submitted by Mr. Abbey as well, which consists of some very faint recordings, none of which substantiate anything that he's claimed, and for the most part are not useful because there's nothing that can really be discerned on these recordings. So as a result of this, I'm finding that domestic violence has occurred and that it is appropriate that an order should be issued and continued. And I will issue that at this time for the next year.
Excuse me, Judge, may I say something?
Keep in mind, I've already made my decision and you've had your opportunity to present your case. This isn't the time to argue, or if you have a question, I may be able to answer it.
Well, she had been holding this over me, that she was going to say this was just domestic violence when she knew it was an accident for 5 weeks now. And she could have called it in.
Mr. Abbey, that's not a question.
Okay. I just wanted to say something. All right. Thank you.
All right, I've signed the order consistently with my ruling. I'm filing it now with the court clerk. It'll be available to both parties from the court's records at any time.
Thank you, Your Honor.
All right, you're welcome.
Okay. Understood. Thanks, Your Honor.
And if not mistaken, yes, I don't see yet that notice of the hearing's been served on Miss Archer.
I can't hear you at all. I'm all
Oh.
stuffed up.
I'm sorry. Do you need a hearing assistance device?
Just walk up here a little closer.
Yeah, you can come a little closer. All right, Miss Carlo, I haven't got any proof that she was served with notice yet.
Oh, okay.
Okay.
I thought Olympia served her. They said they tracked her down to the Holly Motel and served her.
Okay, well, if they did, they haven't filed that
Okay,
yet.
well, I can
I'm
come back.
looking for, I'm just looking to see if it's in here, but I don't see it. Okay. All right, so it's not here. All right, so we'll reschedule this for you.
Okay.
So the temporary order that we issued before is going to remain in effect.
Okay.
And we're going to set a new date. So what have we got? But let's go with the 25th. Okay, so you'll be coming back on November 25th.
Okay. I can find you guys now.
Mm-hmm.
I walked all around up here today. I'm so sorry I was late.
Okay, so did you have Olympia do the service?
Yeah, I
took
took
it to them?
it to Olympia.
Okay.
And
No, you can
I
keep,
saw an officer the following Saturday and he said he was going to serve her at the Holly Motel. So
yeah, you
I
can,
just
you can
thought-
just keep that way if that works for you,
All
that's
right.
fine.
do I take it down to them again? Or do
Yeah.
I wait until the
Yeah,
next
you
order?
can send it to
Okay.
them, take it to them right downtown there. Yeah. Okay, so this is the extension of your anti-harassment order.
Do they need a copy of
Right
that?
here. Yeah, they'll get a copy from you.
Okay.
Yep. So we'll see you on the 25th. This is your petition against Paula Archer.
Yes.
This is number 24-384. Making a final call for Paula Archer.
She's not here.
Okay, yeah. Okay, I don't see her here. I'm going to check the court record and see if anybody has turned in proof of service. Does not appear that they have. Okay, I can give you another continuance, Ms. Carlisle. Try and get her served. Okay, so we'll extend this. All right, Ms. Carlisle, I've extended your temporary order till December 9th.
So I just keep the paperwork I have, yeah.
Yeah, you can, yeah, sir, you can serve that paperwork with her, and the clerk will give you a copy of this, so you've got notice for the new date on December 9th. So Owings versus Howell is the next one. All right, and is it Ania Owings?
Anya.
Anya Owings.
Yeah, and I apologize for going to the wrong courtroom too.
It happens. Okay, and then Ashley Howell, Miss Howell, can you hear us okay?
Yes, sir.
Okay, gotcha. All right, so this is Miss Owings's petition for an anti-harassment order in case 24-358. Yeah. All right, so Miss Owings, you're the petitioner here. You're going to get to present your case first. And after you do that, then Miss Howell, you'll get to respond. I'm going to start by swearing you both in. And then during the time that the other person's telling me their side of the story, just let them do it. Keep in mind that you'll get your chance to tell me your side, or you've already told me your side, so I already know it. And then I'll make a decision as to whether or not the temporary order that was issued previously will continue. All right. So can I have you both raise your right hand, please? And do you each swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, Miss Owings, you get to go first.
So I heard that she is moved to Florida. And if that is the case, like, I don't need to move forward with this.
All right. Well, let me find out. Miss Howell, did you move to Florida?
I did not move to Florida, but I did move out of state, and I am in the South with my family. My family has both my aunt and uncle have cancer. It was already planned for me to move. So yes, I am out of state. I got here.
Just hang on 1 second, okay?
Okay.
Does that change anything for you?
Yeah. I mean, if she's gone, then I don't feel like it's a threat.
Because this can be dismissed if that's what you want to do.
I think dismissing it right now is appropriate.
Okay. All right. If that's what you want to do, we can absolutely do that.
Okay.
So Miss Howell, Miss Owings just wants to dismiss the action, just dismiss the petition. So since she's the person who brought it, she can do that.
Okay, sir. And I just wanted to ask one question. A lot of this stuff on, well, my first question is I've not done anything. Like, my background check is good for like working. I'm very, very worried about employment. And I was wondering, is this on my record if an employer were to pull my background to check for work?
A question like that is difficult to answer, but what I can tell you is that this court has a record of what happened. Now, and that's a public record, and how anyone chooses to respond to that, if they have that information, that's up to them.
Well, that's another issue too, is because I read her stuff and it's false allegations. I have proof. I also,
we don't need to go into that.
Oh, okay. Okay. I just want to, so you're basically saying that if it is a public record, so how long does that stay on for public record?
It is a public record forever.
Oh my goodness. Okay. Way to ruin somebody's life when you don't, I've never even met the lady, so way to ruin somebody's life.
So that the action is dismissed, Ms. Owings, on your request.
Thank you.
And Ms. Howell, that concludes the matter for you.
Thank you.
Is there paperwork or anything?
If you'd like a copy of that now, you can get it, or you can get it from the court record at any time.
Okay. Thank you so much.
You're welcome. So we have, Mr. Murphy, would you come up to the table? We have Falhammer versus Murphy, two cases, 24-329 and 330. And the Falhammers are represented by Mr. Huxford. Mr. Huxford, are the petitioners ready?
Yes.
Okay. All right. And then Mr. Murphy, are you ready?
Yes, sir.
Okay, and you're just representing yourself on this?
Yes, sir.
Okay. All right, I have an initial concern I'd like to address, and this will be to both of you, but I'm going to start with the petitioners. reading the material that's been submitted here in the petition and the petitioner's exhibits, as well as the respondents' exhibits too. What strikes me is that this doesn't really sound like an anti-harassment order petition. It sounds like a civil action in nuisance. I have a couple of reasons for saying that I think are important to how this case may eventually go. I think most particularly the allegations that are raised by the Falhammers have to do with how Mr. Murphy is using his property to create disturbances which affect their quiet enjoyment of their own property, which is why I raise a nuisance as a potential.
Certainly understood, Your Honor.
That is important because the remedies that are available in an anti-harassment petition don't address the complaints that they raise in their petition.
Certainly.
Right. So what's available under RCW 7.105 section 310 is not going to address how loud the car is or whether the car starts early in the morning or late at night. Those are not things that the court can offer relief on under the anti-harassment statute.
Certainly.
So I guess the reason I raise that is, do you really want to be here with this kind of a petition, especially in light of the fact that there was no temporary order issued to begin with?
Certainly.
And that, I suppose, will be my question to you, Mr. Huxford.
I think my response to that, Your Honor, would be the timeline of this case and the facts as represented in not only the initial petition itself, but also the subsequent events that have occurred following the initial hearing, an alleged altercation or something to that effect, some sort of confrontation in the parking lot at the last hearing, words that were exchanged between the parties, specifically Mrs. Falhammer and Mr. Murphy in the courtroom itself. I think what I would also point to the court, this is something that obviously the practitioner immediately came to mind as well, is that a general community nuisance doesn't necessarily create a nexus of facts as it relates to the Falhammer specifically. I think my response to that, Your Honor, would be that we have a general nuisance that then becomes a specific nuisance through retaliation of Mr. Murphy and his girlfriend. I think that what is important for the court to understand is that the email timelines and threads from late July of this year, in which the Falhammers essentially reach out to not only the property manager, but also the landlord specifically, and the HOA president and board to address the very issues that you're discussing. At that point, I would have to concede that it is a general nuisance. However, what then occurs is seemingly retaliatory actions by Mr. Murphy in cold starting this vehicle at all hours of the day, not getting ready for work in the morning, not leaving and coming and going from the house, but just coming outside to turn on his car at 1 a.m. to wake the Falhammers up and specifically retaliate when they have been advised by both the landlord, the property manager, and the HOA that this is an ongoing issue. And so I think that the nexus of facts and the development of these facts as pled is really what's important for the court to hear. Now, as it relates to the remedies, I mean, if Mr. Murphy is excommunicated from going within a certain distance from the house, that solves the problem that we are all addressing. Now, I again understand the court's concern that the specific remedies offered under 7.105 do not necessarily go to the nuisance complaint itself, but I think this is more about presence in the community at large or presence in the neighborhood at large. And so it's my client's desire to move forward. I certainly understand the court's concerns.
Well, let me just follow up then, because the remedy is not available for the court to exclude Mr. Murphy from his residence.
It's not his residence.
What time?
It's not his residence. It's the renter's residence. He's just visiting.
It is our contention that it is not Mr. Murphy's residence. And so
can the district court decide that? The district court doesn't have jurisdiction to decide a question like that. I know that anti-harassment actions are attractive because they're cheap and they're fast, and you get into court immediately, a lot of times without the other side even being present. But addressing the actual substantive issues, I think I can understand people don't always understand that when they come to court. They're not, usually people bring these actions on their own. They're not like legally trained like you are to understand the various different types of causes of action and which courts have jurisdiction over which type and also which remedies are available, which I think is important here. It may be appropriate to think of this in another way, because while we could sit here, we could have a hearing, it could be proved that there is a nuisance going on in the neighborhood, but that's a different thing than proving that there's harassment. And then what can the court actually offer by way of a remedy for any nuisance that's going on? That probably would be nothing. I mean, the court cannot tell him he can't live there. And the court can't tell him when he can come and go or how he can use his property, how anyone can use real property. So it may not be a practical thing to get any relief that would be meaningful. Now, a nuisance action, of course, would provide a whole different set of remedies and damages that aren't available in an action like this. So I'm willing to hear it as an anti-harassment petition. But if it is going to go forward as an anti-harassment petition, I'm not going to consider any nuisance issues. We're going to focus it down to just what constitutes statutory harassment with specific regard to what remedies may be available to address that harassment. Leave them alone, don't communicate with them, don't stalk them, those things are all on the table, but those things don't seem to be what were complained of in the petition. You want to take a minute?
May I? Yeah, if I could take a minute to confer.
Why don't we do that? Let's take a recess. Come on.